Hello and welcome to a special interview for The Wire supported by Glenlivet Books. Do Muslim girls have a fundamental right to wear the hijab in classes? And would it be a breach of Articles 14 and 25 of the Constitution if that's denied to them? Or do schools have a right to scrupulously enforce their uniform regulations? Those are the two key fundamental questions that underlie the present dispute in Karnataka. And those are the very questions I'm going to put today to one of the Supreme Court's leading lawyers, Sanjay Hegde. Mr. Hegde is presently the lawyer for the Udupi girls at the Karnataka High Court. Sanjay Hegde, I'm going to put those two fundamental questions to you one by one so that the audience can understand the issues that are involved in both of them. First, do girls have a fundamental right to wear a hijab in classrooms? And would it be a denial of their rights under Article 14 and 25 of the Constitution if they are not permitted to wear the hijab?
Thank you, Karan, for having me. Let me start with a disclaimer. I am not going to re-argue whatever I've argued in court. I am using this opportunity to just clarify the legal issues for the very wide audience that you and Glenlivet Books have. So the question here is, do the girls have a fundamental right to wear a hijab? Yes. Does the fact that they are going into a classroom make a difference? Well, if there is a uniform code which is specified with the authority of law, that law would have to be tested for constitutionality against the girls' fundamental rights. If the state claims any overweening interest or in denying the hijab, the state would have to provide a justification. I'd also like to say that here it is the uniform itself prescribes the dupatta. Now, whether a dupatta is worn on the shoulders or over the head is, I don't think, any breach of any uniform code. As for the hijab per se, in all situations, in public squares, in public places, there is no ban whatsoever. And I don't think that any court would uphold a public ban on the hijab in public places.
Absolutely. The question is finally about, can the hijab be worn in classrooms? Is there a fundamental right that permits it to be worn, or is there a question of different interpretations? Now, I believe different high courts in India at different times have taken almost polar opposite stands on this issue. Can the hijab be worn in a classroom? In 2002, the Bombay High Court ruled that denying girls permission to wear the headscarf would not interfere with the essence of the Muslim religion or Islam. But both in 215 and 216, the Kerala High Court said something else. On both occasions, the Kerala High Court permitted the hijab to be worn by girls whilst taking pre-medical exams. But then 3 years later, the same High Court, Kerala, in 2018, almost changed its opinion. It said that, in fact, schools could not be ordered to permit the hijab. And it went on to say that in this instance, the individual interest must give way to the dominant interest of the institution. So clearly, we've got different views from different high courts at different points of time on this critical single issue. Can the hijab be worn in classrooms? Doesn't this mean we don't have a clear legal stand?
There is no clear legal stand because there has been no legislation. Interpretations are context specific. You mentioned the last Kerala High Court judgment. That was in the context of a minority educational institution of the Christian community. Now, if that minority institution were to prescribe a uniform code for all students, would the institutional interest prevail or would individual interest prevail? is a balancing act that the single judge in Kerala took. He was the same judge who was there in the other Kerala case, which was a division bench, where for an exam, could people still insist on wearing a hijab? You know that with modern technology, with Bluetooth and all that, if somebody is wearing some concealing attire in which things can be concealed, there could be a possibility of cheating. So for that fine distinction, for that one period alone, the Kerala High Court came out with a via media. They said, okay, you come to the exam center earlier. There will be women who can check you, and then you can wear the hijab. So while there is a fundamental right to wear a hijab, if there is an overweening state interest at a specific point of time, then a via media would have to be found out. But you cannot uniformly ban, nor can you say that if you wear it, you will not have access to education.
You're making.
And just one last sentence, Karan. I don't want to put the hijab on trial anywhere. What I want to see is what our country does to see that religious considerations do not come in the way of female education.
Absolutely. Now, you made a very important point about those different and disparate high court judgments, whether Bombay or Kerala. You said, first of all, they were interpretations. They weren't actually laying down the law. And secondly, they were context specific, and therefore they apply only to the specific context in which the petition was made. This actually then takes us to the law laid down by the Supreme Court in what's called the 1954 Shirur Mutt case, where the Supreme Court ruled that religion covers all beliefs and practices integral to a religion. And that therefore raises the question, is the hijab integral to the Muslim faith? And before you answer, let me point this out. In Muslim countries like Kosovo, Azerbaijan, Tunisia, and to a certain extent in Turkey, the wearing of the hijab is banned. I'll repeat that, banned in schools, universities, and government buildings. Turkey, however, seems to be changing its position under Erdogan. In other countries, Indonesia, the world's biggest Muslim country, Malaysia, Morocco, Brunei, Maldives, Somalia, it's optional. It's not mandatory. So these Muslim countries clearly suggest that in their interpretation, the hijab cannot be integral because it's either banned or it's optional. What's your opinion? Is it integral? Will it come under the law as laid down in 1954?
The first thing that I'd like to point out is that the 1954 judgment was in the context not of a minority, but it was in the context of a Hindu temple itself from my hometown of Udupi. What is integral? What are the integral practices of the Hindu faith with respect to temple management was the issue there. So this essential religious practices test was laid down, not as a protection for the minorities, but as a general interpretation of the constitution itself.
But will it differ? Will that essential practices test differ if it's used to define elements of the minority faith? Surely not.
Surely not, and I hope not. I hope not. I was making the point for your viewers that this was a constitutional interpretation, not in the context of a minority. It was in the context of the faith of a majority of citizens, and all citizens have an equal faith in the constitution.
Absolutely. But that simply is going around the question I asked. Because under 1954,
is
the hijab integral? What's your answer?
No, here, I'm answering like a lawyer. And the point is that I am not qualified to be an authority on Islam. I can only provide evidence. I can provide the Quranic verses. I can provide the Quranic verses. I can provide evidence of usage and what each what different followers of the faith either follow or not follow. Sometimes the evidence also may be irrelevant, because as long as there is a practice in certain sections of the faith which is consistently followed, and the individual, out of his or her own free conscience, follows that particular practice, is it entitled to protection?
You're making a very important point, Mr. Hegde. And what you're saying, and in a sense, I'm extrapolating and interpreting what you're saying, is that it doesn't matter that countries like Kosovo, Azerbaijan, Indonesia, Morocco may not consider hijab integral. If a sizable section of Indian Muslims do consider it integral, it is integral for them. Now, that is an interpretation, that is a reading the Supreme Court will have to do. The problem is, the Supreme Court consists of judges who are learned in the law, not learned in religion, and definitely not learned in Islam. Therefore, they will rely on experts. But the problem is, different experts themselves have very individual viewpoints, right? They are not necessarily always speaking from the point of view of people they disagree with. They will present the point of view of their own interpretation. Therefore, you could have two different experts saying two different things. Once again, how on earth does the Supreme Court decide what is integral or not?
Well, that is why Supreme Court judges themselves, in their judgments, have criticized this essential religious practices test. They say that it has almost made them dharmashastris, or interpreters of religious texts rather than constitutional texts.
Absolutely.
The Constitution requires them to protect religious freedom of religion in this country. Somebody asserts that this is a genuinely held belief and there is religious ground for it. Now, can you deny them that? So therefore, I would much rather say, point out to conscience, the freedom of conscience, which is also guaranteed in the Constitution.
Okay.
If you conscientiously hold a belief, and there is justification for that in the text, plus there is evidence of its large practice, then if you are to deny that particular practice, if the state were to deny it by legislation or any other manner, the state should have to have very great justification for such denial.
Let me sum up what you're saying, because I think it's a very important point. You do agree with me that it's almost impossible for judges to infallibly rule what is integral, what is essential to a faith, and what is not, because they're not experts in the field, and different experts will give them often conflicting advice. Therefore, if someone conscientiously believes that something is integral to their faith, you must accept it, because it's their conscientious belief. Others can't determine that belief for them. And therefore, if these girls believe conscientiously that this is integral to their faith, it must be accepted, because there's no way of a third person determining whether it actually is or not. Therefore, you accept what people say, don't challenge it, as long as it's their conscientious belief.
And let me refine that slightly further. If that is their conscientious belief, and the state wants to interfere in that belief, then the state must have very great justification for that.
Yes.
And that interference must be only to the extent that is absolutely necessary.
Absolutely. I don't want to go further down this road, but I will point out that your position leads to the conclusion that the Sabrimala judgment was wrong, because the state interfered and decided that something that was conscientiously held by believers was not right. And therefore, to follow your line of logic, one has to end up saying that the Sabrimala judgment imposed a third person's attitude and belief over people who conscientiously believe the opposite. But I won't go further down that road. I'm simply pointing that out.
No, let me answer you there. Shabrimala, and the ultimate analysis was a judgment based upon a rule, which a man-made law. There was a rule under the Kerala Temple Act which noticed this practice and said that therefore women should not go. So it was a man-made rule that was struck down. Now, when it comes to Hindu temples, there are also portions of the constitution in the fundamental rights which say that Hindu temples should be open for all. So you can't necessarily exclude people.
Okay, I take your point. I take your point. Let's come at this point to the second basic fundamental question that underlies the dispute in Karnataka, and that is to do with the fact, do schools have a right to insist that their uniforms are scrupulously observed? And if they do have that right, and they find that the hijab is not part of the uniform, then can they not say, sorry, you cannot wear the hijab?
Now, there are schools and schools. There are private sector schools. There are schools run by minorities which have the right to establish educational institutions of their choice. Then there are government schools. And this problem started with not a school, mind you. It started with a government pre-university college. Now, the idea of a uniform in college is something that rebellious teenagers over a large portion of India will certainly not accept. However, there are certain states where you have a uniform for a college. But can a educational institution say that there has to be a uniform, and that uniform will make no exception whatsoever for religious purposes? That is the real question.
Well, hang on, let me come back there. A convent would clearly say you cannot wear a hijab in class. And there are many Muslim girls who go to convents, and they don't feel their religious rights are being tampered with or interfered because they can't wear a hijab in a convent. No, so if a convent can lay down and be legally permitted to say no hijabs, and if Muslim girls who go there don't object, then why object if a pre-university college in Udupi says the same thing?
Okay. Now, the answer there is a convent by definition consists of women. A non-hijabi girl, a girl who otherwise observes the hijab, need not veil herself before other women. So there is a difference altogether. It's a different argument. As far as a government college is concerned,
Can I come in there? Don't take the word convent literally. Think of it as missionary schools. Missionary schools would not permit girls to wear hijabs, and missionary schools are often co-educational. Now, if it's okay for a Muslim girl to accept no hijab can be worn in a missionary school, why should the girl object when a pre-university college in Udupi does the same?
See, it's a question of religious faith and how religious that girl is. If a girl has a religious faith, that she will not go to any place where she is required to take off her hijab. And if as a consequence of no hijab being allowed, she has to remain at home and not go to college, the question is, would a government college necessarily make a rule which it knows will have the effect of exclusion?
In other words,
that is
what you're saying is how government colleges make rules that affect girls' educations is different to how missionary schools or convents make those rules. Missionary schools and convents are essentially private. Government schools are not. Government schools, therefore, can't make rules that would end up excluding girls from being educated. That's the point you're making.
Yes, excluding any section of the population. You may have a choice when you get into a missionary or a private sector college. If one college doesn't allow you, you may go into another college. You are making a choice when you pay. But as far as government is concerned, where there is equality of opportunity towards education, there has to be an equalization also.
Let me then take your point further and ask a question, this time from the opposite standpoint. If these government colleges, and I'll take in particular the pre-university government college in Udupi, if it is
Yes,
going
my
to
hometown.
rule, absolutely your hometown, that's why I'm taking this example. If that college is going to rule that girls can't wear hijabs, then ipso facto, shouldn't they also say that Hindu boys cannot come with large and visible Shaivite and Vaishnavite tikkas on their forehead, that Hindus can't come with large red mollies like this, which is looking bedraggled on their hands? Because if you ban one, you have to ban the other. You can't permit one but ban one, because that is illogical, inconsistent, and unfair.
That could well be the argument, but that is not the country that we are. We are not like France, which bans all displays of religion, religious displays, whether it be the crucifix, whether it be the hijab, or whether it be even the Sikh turban in public places. We are not that kind of country. We are a country which says, whose version of secularism is essentially pluralism. We are a country that prides ourselves in its diversity.
Which is why I asked this question, because the Udupi Pre-University College ban on hijabs is going halfway down the laissez-faire route of France, but only for Muslim girls. So if you are going to go down that route for Muslim girls, you have to go down a similar route and stop Hindu boys wearing Shaivite and Vaishnavite tikkas or molly threads on their hands. But you can't ban one and not ban the other. That's the point.
Yes, exactly. I agree. And then there would come all those other questions as to whether the school prayer should be rooted in Hindu scripture or not, or whether lighting of a ceremonial lamp, whether it violates any notion of the strict neutrality which is required by the French model.
Absolutely.
We are not the French model.
Absolutely. Once you start going down this route, where do you stop? But let me ask you two more questions before I end this interview. There's a certain amount of confusion, perhaps it's been deliberately created, about when this problem started. The girls who are not being allowed to wear the hijab have told many television channels and newspapers that for years they were permitted to wear it, but sometime in December, suddenly, the colleges stopped giving them permission and said this can't be worn. On the other hand, the school education minister of Karnataka, Mr. B.C. Nagesha, said exactly the opposite. He said hijabs were never worn for years. Suddenly in December, the girls started wearing it. So what's the truth?
Well, I have I placed yesterday before the Karnataka High Court, the writ petition, which on fact stated a whole series of incidents from September onwards. They were always wearing the hijab, but there was a particular teacher who took objection to that, and who said that even in the past, when people tried to do it, they wore it, she would get other students to pull it off, and that the consequences were not good with her. The girls went and complained to the principal. The principal took no action. Then their parents came to school. They were denied an audience. Then they went to the district education officer, who told the principal, stop all this, do not trouble them. At which point of time, the principal then went to the local MLA, who happens to be the chairman of the school committee. And that's where the problem actually arose. So you see, I keep telling people that a local problem which could have been handled by teachers who are interested in teaching and not in ideology would not have gone into this threatening conflagration that is not good for the country.
Absolutely. There's no doubt it's been politicized, and no doubt perhaps it's been politicized from both sides. But the point you're making, and I'm just repeating it for clarity, is that hijabs were being worn in that college for years. The problem began in September with one individual teacher objecting, and then it, from that point onwards, escalated. So, in fact, what that means is that the Karnataka Education Minister Nagesh is wrong. The girls who've been speaking on TV and into newspapers are right. The hijab was worn and accepted for years. In September, an individual teacher created a problem and it then escalated. In other words, this refusal to allow the hijab is recent.
Absolutely. Absolutely. That is the statement on averment before the High Court. And of course, there will be some of your viewers who will say that, look, here the lawyer has to stick to his brief.
Absolutely, but I presume the lawyer.
I stay there.
But I presume that the lawyer is not telling an untruth. I presume, even though you're sticking to your brief, you will not be misleading the Karnataka High Court by telling them an untruth. That is an assumption that I think we can safely make. Otherwise, you would be guilty of God knows what the law is, but perhaps even contempt. Two last questions. Late on Saturday night, the Karnataka government invoked the 1983 Karnataka Education Act and enforced Section 133(2) of that act, which says, and I'm quoting, clothes which disturb equality, integrity, and public law and order should not be worn. Can the hijab be deemed to disturb equality?
Well, the point is that it is not the section. The section doesn't provide for that. In the Karnataka Education Act, there is not one word on a uniform. All these have come by administrative orders and rules. And this was a government order which based itself on the rules. And it has made a value judgment. It has made a value judgment that a hijab disturbs national integrity. I don't think so. I think we are a nation.
What about equality? What about equality? Sartorial equality, the belief that students in school should dress alike, there should be no sartorial differences.
We don't go by beliefs in that sense. We go by the law and the letter of the law. Show me the law. There is no legislation.
You're making a very important point, Mr. Hegde. You're saying that, in fact, the Karnataka Education Act of 1983 has nothing to say whatsoever with the wearing of uniforms. Rules Absolutely. That may thereafter have been devised to implement the act may refer to them, but there is no law behind those rules. And secondly, you also dispute the claim that differences in uniform lead to inequality. Identical similarity of uniforms is not a way of enforcing equality. You're making all those points, aren't you?
Absolutely. Uniformity in a diverse country, that's the additional point. Uniformity in a diverse country is not necessarily a constitutional value.
My last point. Yesterday, Thursday, the Karnataka High Court orally, I underline that word, orally said that
Karan, let me correct you there. The order has come out.
So they have now actually issued an order asking girls not to wear the hijab, asking all other people not to wear religious attire until the High Court decides the matter. Which means that when Karnataka colleges open on Monday, the wearing of any form of religious attire, but as far as we're concerned, the wearing of hijabs by girls has been disallowed by the court. How do you respond to that?
Well, it's a very carefully crafted order, and every word will be weighed. I would not want to say anything on your show which would possibly prejudice the case further in any manner whatsoever.
I understand your reluctance to speak on this specific issue because you don't want to prejudice the matter. After all, you are one of the senior lawyers connected with this case. But your fellow advocate, who's also connected with the case, Mr. Kamath, has said in court, and he's been widely reported in the papers, that this would be tantamount to denying the concerned girls their constitutional rights even before the court has decided in the matter. And to laymen like me, I emphasize, to laymen like me who are not learned in the law, this clearly looks as if the court is taking a decision before actually formally taking a decision and imposing it. And it's very strange for the court to impose a decision when it's actually still looking into the matter. So there's a certain contradiction in the way the court is behaving, and it will become even worse if the court finally decides that hijabs can be worn, because in the interim, it would have disallowed them.
Well, Karan, I'm a lawyer, and one of the signs of a good lawyer is knowing when to shut up.
As Javed Akhtar said in one of his most beautiful songs, Kuch na kaho.
Sometimes that discretion is the better part of valor, and particularly on emotive issues. The less we speak and the more we think, it will be a much better nation. Unfortunately, in this country, we are addicted to sound bites which go out on YouTube, on WhatsApp and whatnot. Our attention spans are very small, and we want instantaneous decisions. That's not how a careful country can evolve.
I understand, I respect your silence, and I hope that judges themselves will give you credit for your restraint and your refusal to enter areas where the controversy can only damage the issue and perhaps create emotions that will conflict. But I want to also thank you, Mr. Hegde, for having done this interview, despite the fact that you are one of the lead lawyers connected with the case, and for having explained the issues to the audience. Because I think it's important that the Indian people should understand, A, what are the issues involved, B, what is the law such as it is on this matter, and C, the very important point you made, which may be your own interpretation, but it's a very important point, that ultimately, when it comes to having to decide what is integral to a faith, it's best for judges not to step in and claim they're doing so, even if it's done on the basis of evidence given by experts. It's much better to say that if people conscientiously believe something is integral to their faith, then accept it, because it is integral to their faith in their eyes, and that is the basis upon which they lead their lives. I thank you for this, Mr. Hegde. I think it will bring a lot of clarity to the Indian people. Take care, stay safe.
Thanks, Karan.